I was loading my grain harvester onto the trailer when I noticed the silver BMW pull up to my driveway, and my stomach immediately dropped because I knew exactly who was behind the wheel. Sharon Patterson stepped out of her car wearing white Capris and a pink blazer that screamed middle management. Her highlighted blonde hair perfectly styled, despite the humid July heat in rural Georgia. She carried a leather folder under her arm and had that look on her face, the one that said she was about to ruin someone's day and enjoy every second of it. "Excuse me, Yates Brennan," she called out, her voice dripping with fake politeness. I wiped the grease off my hands with a rag and walked over. "That's me. Can I help you?" "I'm Sharon Patterson, president of the Meadowbrook Estates Homeowners Association. I'm here about multiple violations occurring on your property." I looked around my 10-acre lot, confused. I'd moved here 6 months ago specifically because I wanted space for my small farming operation. The house was a modest ranch-style home, but the land was perfect for what I needed. "What violations?" Sharon opened her folder with a flourish. "According to Section 4.2 of our HOA covenant, no commercial vehicles or equipment may be stored on residential properties. You currently have a combine harvester, 2 tractors, a hay baler, and various other agricultural equipment visible from the road." "This is farmland," I said, trying to keep my voice level. "I run a small farming business. That's the whole point of buying property out here." "Meadowbrook Estates is a residential community," Sharon said, her voice getting sharper. "We have standards to maintain, property values to consider. Your equipment is an eyesore and violates our community guidelines." I felt my jaw tighten. When I bought this place, nobody mentioned anything about an HOA. I specifically looked for property where I could operate my farm. Sharon pulled out a sheet of paper. "Every property in this subdivision is part of the HOA. It was established in 1998. You should have received documentation during closing." I remembered the mountain of paperwork from the closing, most of which my lawyer had reviewed. "Even if that's true, this land has been used for farming since before any subdivision existed. The previous owner grew soybeans here for 30 years. "The previous owner was grandfathered in," Sharon said dismissively, "but he moved to a nursing home and sold the property. The new owner, you, must comply with current HOA regulations. You have 14 days to remove all equipment or face daily fines of $500. $500 a day." My head spun with the math. That would bankrupt me in a month. "This is insane," I said. "I can't just move my equipment. I have contracts with local farms. I do custom harvesting for 6 different properties in the county." Sharon snapped her folder shut. "That sounds like a commercial business operation, which is also prohibited in residential zones." "You have 14 days, Mr. Brennan. The notice will be mailed to you officially tomorrow." She turned on her heel and walked back to her BMW, leaving me standing in my driveway feeling like I'd been sucker punched. That evening, I drove into town to see my lawyer, Marcus Webb. His office was above a hardware store on Main Street in Jefferson, the county seat. Marcus was in his 60s, with gray hair and reading glasses that perpetually sat on the end of his nose. He'd handled my property purchase and had been practicing law in Jackson County for 40 years. "Yates," he said, gesturing me into his cluttered office. "What brings you by?" I explained the situation with Sharon and the HOA. Marcus listened, his expression growing more serious as I talked. "You have your deed?" he asked when I finished. "In my truck. Go get it." I retrieved the deed from my glove compartment and handed it to Marcus. He put on his reading glasses and started reading carefully, his finger tracing down the page. Then he stopped, went back, and read a section again. "Well, I'll be damned," he muttered. "What?" Marcus looked up at me with a slight smile. Yates, do you know the history of your property? Just that the previous owner, Mr. Henderson, farmed it for decades. It goes back further than that, much further. Marcus pointed to a paragraph in the deed I'd never paid attention to. See this. This is what's called an agricultural covenant. It was placed on this land in 1887, back when this whole area was farmland. The original landowner, a man named Thomas Brennan, actually, might be a distant relative of yours, established this covenant to ensure the land would remain in agricultural use in perpetuity. In perpetuity. Forever. The covenant states that this land must be permitted for agricultural use regardless of any subsequent zoning changes, regulations, or restrictions. It runs with the land, meaning it transfers with every sale and supersedes almost everything else. I felt a surge of hope. So the HOA can't stop me from farming. Not just that, Marcus said, his smile widening. They can't enforce any restriction that interferes with your agricultural operations. This covenant predates their HOA by over a century. It's ironclad. In Georgia property law, a covenant like this, especially one this old and consistently honored, takes precedence over HOA rules. So I can tell Sharon Patterson to pound sand, Marcus chuckled. More or less, though I'd word it more diplomatically. Let me write you a letter explaining the legal situation. But Yates, be prepared. HOA presidents like this Sharon woman don't back down easily. They hate being told they're wrong. Marcus was right about that. 3 days later, I received the official violation notice by certified mail. It was printed on expensive letterstock with the Meadowbrook Estates logo at the top. The notice repeated what Sharon had told me and included photos of my property showing my equipment. At the bottom was the threat of $500 daily fines beginning in 11 days. I also received Marcus's letter, which was 3 pages of dense legal language that basically said the HOA had no authority over my agricultural operations due to the 1887 covenant. Marcus had included copies of the relevant deed sections and cited half a dozen Georgia court cases supporting our position. I made copies of everything and drove to the address listed for HOA correspondence, which turned out to be Sharon Patterson's house. It was a large colonial-style home in the newer section of the subdivision, with a perfectly manicured lawn and flower beds that looked like they'd been planted with a ruler. Sharon answered the door in yoga pants and a tank top, her face flushing when she recognized me. Mr. Brennan, you need to schedule appointments. Just delivering a response to your violation notice, I said, handing her the envelope containing Marcus's letter. Sharon opened it right there and started reading. I watched her expression change from annoyed to confused to angry. This is ridiculous, she said. Some ancient document doesn't override our current HOA rules. Actually, it does. My lawyer cited the relevant cases. The agricultural covenant is legally binding and takes precedence. We'll see about that, Sharon snapped. I'm forwarding this to our HOA attorney. You'll be hearing from them. 2 weeks passed. The deadline for removing my equipment came and went. I kept farming, finishing up the wheat harvest for one of my client farms. Every day I half expected another notice, but nothing came. Then I got a letter from a law firm in Atlanta, Rothman, Chen, and Associates. It was from an attorney named David Rothman, representing the Meadowbrook Estates HOA. The letter was more professional than Sharon's notice but basically said the same thing: remove the equipment or face fines. However, there was something new. Rothman's letter argued that the agricultural covenant only protected actual farming of my land, not storing equipment or running a commercial farming business that served other properties. They claimed my operation exceeded the scope of the covenant's protection. I took the letter to Marcus. He read it and shook his head. They're grasping at straws. The covenant specifically mentions agricultural operations and related activities. That's pretty broad language. Storage of equipment needed for farming clearly falls under related activities. So what do we do? Write back and hold our ground. If they want to push this, they'll have to take it to court, and I don't think they want to do that. Court is expensive, and they'll lose. Marcus drafted a response explaining why the HOA's interpretation was wrong. He pointed out that agricultural operations in 1887 and now have always included equipment storage, and that limiting the covenant to only on-site farming would render it meaningless for modern agricultural practices. I thought that would be the end of it. It wasn't. A month later, I was working in my shop, rebuilding a hydraulic cylinder, when I heard vehicles in my driveway. I walked outside to find 2 Jackson County Sheriff's deputies standing next to their cruiser, along with Sharon Patterson, and a man I didn't recognize wearing an expensive suit. My heart started pounding. "Can I help you, officers?" The older deputy, whose name tag Reed Morrison, stepped forward. "Are you Yates Brennan?" "Yes, sir. We have a court order requiring you to cease commercial business operations on this property." He handed me a document. I took it with shaking hands. It was an emergency injunction signed by a judge. I scanned the page, trying to make sense of the legal language. "I don't understand," I said. "What commercial operations?" The man in the suit spoke up. "I'm David Rothman, attorney for the Meadowbrook Estates HOA. The court has granted a temporary injunction prohibiting commercial farming operations on residential property pending a full hearing on the HOA's enforcement action." "But I have a covenant," I protested. "An agricultural covenant from 1887. "Which is being disputed in court," Rothman said smoothly. "Until the matter is resolved, you must cease business operations." Sharon stood behind Rothman with her arms crossed, looking triumphant. Deputy Morrison looked uncomfortable. "Sir, I'm not here to take sides. But this is a valid court order. You need to comply." "Can I still keep my equipment here?" Rothman consulted his copy of the order. "Equipment storage is permitted temporarily, but no commercial farming activities conducted from this location." After they left, I immediately called Marcus. He was furious. "They judge-shopped," he said. "They filed in magistrate court with a judge who doesn't know property law. This is a temporary order, Yates. We'll fight it at the hearing." "When's the hearing?" "Should be scheduled within 30 days. I'll file our response tomorrow." "Don't worry, we're going to win this." But I was worried. Without being able to operate my business, I'd lose my contracts. I had a combined payment due in 3 months. I had insurance, fuel costs, maintenance. My whole livelihood depended on farming. The next 2 weeks were hell. I had to call my clients and tell them I couldn't fulfill my harvesting contracts due to a legal dispute. Most were understanding but had to find other contractors. One farmer, Bill Henderson, the nephew of the man who'd sold me the property, was particularly sympathetic. "That HOA's been trying to force out farming for years," Bill told me over the phone. "They want to turn this whole area into cookie-cutter suburbs. My uncle fought them for a decade before his health gave out. That's why he put that covenant in your deed's title when he transferred it." "Well, technically it was already there from way back, but he made sure it was prominently listed. I wish he'd mentioned it to me directly. Uncle Frank wasn't much for talking his last few years, but he knew what he was doing with that covenant." "You got yourself a good piece of legal protection there, long as you fight for it." The hearing was scheduled for August 15th at the Jackson County Courthouse. Marcus filed a motion to dismiss the injunction and to recognize the agricultural covenant's supremacy over HOA regulations. The HOA filed a counter motion arguing the covenant was outdated, too vague to enforce, and didn't extend to commercial operations beyond the property boundaries. I spent the week before the hearing helping Marcus prepare. We gathered evidence of the property's continuous agricultural use since 1887. The county clerk's office had old records showing the land had been farmed for generations. We found property tax records listing it as agricultural land. We even found photographs from the 1920s showing the original barn, some of which was still part of my current shop building. Marcus also prepared a list of witnesses, including Bill Henderson and 2 other longtime farmers who remembered when the whole area was farmland before suburban development started creeping in. The night before the hearing, I barely slept. Everything I'd worked for was riding on tomorrow. I'd spent 10 years building my custom harvesting business, saved every penny for a down payment on this property, and invested everything in equipment. If I lost, I'd have to sell at a loss, probably file bankruptcy, and start over somewhere else. The courthouse was packed when I arrived the next morning. Apparently, word had spread about the case, and it had drawn attention from other farmers worried about HOA encroachment, and from HOA supporters who wanted to see agricultural operations banned from residential areas. The hearing was in front of Judge Patricia Walsh, a sharp-eyed woman in her 50s with a reputation for being thorough and fair. She sat at her bench reviewing documents while both sides assembled at their tables. Marcus sat on my right, looking confident in his navy suit. Across the aisle, David Rothman had 2 associates with him, along with Sharon Patterson and 3 other people I didn't recognize, presumably other HOA board members. "All rise," the bailiff announced, though we were already standing. Judge Walsh looked up. "Please be seated. We're here on the matter of Meadowbrook Estates Homeowners Association versus Yates Brennan regarding enforcement of HOA covenants and an agricultural land use dispute. Mr. Rothman, you filed for the injunction. Present your case." Rothman stood and launched into a polished presentation. He argued that the Meadowbrook Estates subdivision was established as a residential community with clear rules to maintain property values and neighborhood character. He showed photos of my equipment, arguing it was unsightly and inappropriate for a residential area. "The defendant operates a commercial farming business," Rothman said. "Not a small family farm, but a for-profit enterprise that serves multiple properties throughout the county. He parks massive industrial equipment on his property, visible from the road, creating noise, dust, and traffic. This violates the reasonable expectations of his neighbors in a residential community." Rothman then addressed the agricultural covenant. "Your Honor, the document Mr. Brennan relies on is over 130 years old. It was written in a completely different era when this entire area was farmland. The covenant's language is vague and outdated. It doesn't specifically authorize commercial farming operations or equipment storage for off-site work. At most, it protects traditional farming of the land itself, which Mr. Brennan isn't even doing. He grows nothing on his property. He simply uses it as a base for his commercial business." Judge Walsh listened without expression, taking occasional notes. When Rothman finished, Marcus stood up. He was calm and measured, very different from Rothman's aggressive style. "Your Honor, this case is actually quite simple. Mr. Brennan owns property subject to an agricultural covenant recorded in 1887. That covenant is clear and unambiguous. It states, and I quote, 'This land shall remain in perpetuity available and permitted for agricultural operations and related activities, regardless of subsequent changes in surrounding land use or regulatory restrictions.'" Marcus walked the judge through the covenant's history, and the relevant case law. He cited a Georgia Supreme Court decision from 2015 that had upheld a similar agricultural covenant against a municipality's zoning restrictions. The HOA argues the covenant is outdated, Marcus continued. But perpetuity means perpetuity. The covenant was written to be permanent, and Georgia law respects that. The HOA argues Mr. Brennan's operations are commercial, as if that matters. All farming is commercial. Farmers sell their crops and services for profit. That's how farming works and has always worked. Marcus then presented photographs showing the property's continuous use for agriculture, including images from different decades showing various farming operations. As for the argument that Mr. Brennan doesn't farm his own land, that's irrelevant. The covenant protects agricultural operations, which includes modern farming practices. Custom harvesting, where one farmer provides services to others, is a recognized and common agricultural practice. Mr. Brennan's equipment must be stored somewhere. The covenant explicitly protects related activities, which obviously includes equipment storage. Marcus paused and looked directly at Judge Walsh. Your Honor, the real issue here is that the HOA doesn't like farming. They want to eliminate agriculture from their neighborhood to maintain an aesthetic preference. But they don't get to override a legally binding covenant that predates their organization by a century. Property rights matter. Covenant law matters. The HOA had full access to property records before purchasing their homes. The agricultural covenant was recorded and available for review. They bought with notice of Mr. Brennan's rights. Judge Walsh asked a few questions about the specific language of the covenant and the scope of my farming operations. Then she turned to Rothman. Mr. Rothman, you've argued the covenant is too vague to enforce, but it seems quite specific to me. Agricultural operations and related activities. How is that vague? Rothman stood again. Your Honor, what counts as related activities? The covenant was written when farming meant horse-drawn plows and simple tools. The defendant has industrial equipment worth hundreds of thousands of dollars. The law has always recognized that covenants must be interpreted in the context of modern practices, Judge Walsh said. Otherwise, every covenant more than 50 years old would be unenforceable. But Your Honor, this covenant shouldn't trump the reasonable rights of an entire community to maintain residential character. The community chose to develop around land with an existing covenant, the judge said. They can't claim surprise. Rothman tried to argue further, but I could see Judge Walsh wasn't buying it. After another 20 minutes of back and forth, she called for a brief recess to review the documents and case law. Marcus leaned over to me. It's going well. She gets it. You sure? Judge Walsh is smart. She sees through their nonsense. When court reconvened, Judge Walsh delivered her ruling. I've reviewed the agricultural covenant, the deed history, and the applicable case law. The covenant at issue is clear, recorded, binding, and enforceable. It explicitly protects agricultural operations in perpetuity, regardless of subsequent regulations. The HOA's covenants, created over a century later, cannot override this existing property right. She looked at Rothman. The HOA's arguments about commercial operations are unpersuasive. All farming is inherently commercial. The covenant doesn't distinguish between farming one's own land versus providing agricultural services to others, and I see no legal basis to create such a distinction. Then she turned to me. Mr. Brennan has a protected property right to conduct agricultural operations, including equipment storage and modern farming practices, on his land. The temporary injunction is dissolved. The HOA is prohibited from enforcing any rules that restrict Mr. Brennan's agricultural activities. Relief flooded through me. Marcus shook my hand under the table, but Judge Walsh wasn't done. Furthermore, I'm ordering the HOA to pay Mr. Brennan's legal fees. This lawsuit was without merit and caused unnecessary harm to Mr. Brennan's business. The covenant was clear, and the HOA should have recognized that before seeking judicial intervention. Sharon Patterson's face turned bright red. She leaned forward and whispered urgently to Rothman, who looked unhappy but unsurprised. After the judge left, Marcus and I walked out of the courtroom into the hallway. Several farmers who'd been watching, including Bill Henderson, congratulated me. "You did the whole county a favor," Bill said. "Maybe now the HOA will think twice before trying to push out agriculture." Sharon Patterson stormed past us without a word, her high heels clicking on the marble floor. I thought that was the end of it. I should have known better. 2 weeks later, I got my farming business back on track. Most of my clients were willing to work with me again once they heard about the court ruling. I was in the middle of a corn harvest when my phone rang. It was Marcus. "Yates, we have a problem." My stomach sank. "What now?" The HOA filed an appeal. "They're taking it to the Georgia Court of Appeals." "Can they do that?" "Unfortunately, yes. Anyone can appeal. It'll drag this out for months, maybe a year or more." "But I won the case." "You did. And you'll win the appeal too." But in the meantime, they're trying to make this as expensive and difficult as possible. It's a harassment tactic. I felt anger rising in my chest. They're doing this out of spite, basically. "Look, my fees are covered by the court order, so you won't owe me anything additional." But this is going to be a headache. They know they'll lose, but they're hoping to pressure you into a settlement. I'm not settling. Good, neither am I. Over the next few months, the appeal process ground forward. Marcus filed briefs, the HOA filed responses, and we waited for the appeals court to schedule oral arguments. In the meantime, I kept farming, but the stress was constant. The worst part was the hostility from some of my neighbors. Not everyone in Meadowbrook Estates was against me. Plenty of people didn't care or even supported my right to farm. But Sharon had rallied her supporters and they made their feelings known. Someone spray painted "No Farms" on my mailbox. I replaced it. They did it again. The third time, I installed a security camera which caught a teenage kid doing it. I recognized him as the son of one of the HOA board members. I sent the video to the sheriff's department, and the kid got charged with vandalism. Then someone filed a noise complaint claiming my equipment was too loud. The county sent an inspector who measured the decibel levels and found I was well within legal limits. Someone else reported me to the EPA, claiming I was polluting groundwater. That triggered an inspection that found nothing wrong. It was death by 1,000 cuts, and I knew Sharon was behind it, even if she was using proxies. The breaking point came in November. I was combining soybeans on a client's farm about 15 miles from my house when I got a call from my neighbor, an older woman named Dorothy Mills who lived on the property adjacent to mine. She was one of the few neighbors who'd been friendly to me. "Yates, you need to come home right now," Dorothy said, her voice shaking. "What's wrong?" "There are people on your property, they have trucks and they're taking your equipment." I felt my blood run cold. "Call the sheriff, I'm on my way." I drove like hell back to my place, probably breaking every speed limit. When I pulled into my driveway, I found chaos. 2 flatbed tow trucks were there, along with Sharon Patterson, David Rothman, and the same 2 sheriff's deputies from before. My grain trailer was already loaded on one truck. They were working on securing my smaller tractor to the other. I jumped out of my truck. "What the hell is going on?" Deputy Morrison stepped forward, looking even more uncomfortable than last time. "Mr. Brennan, they have a writ of execution for unpaid HOA fines." "What fines?" The judge threw out their case. Rothman stepped forward with a document. The judge ruled on the covenant issue, but there were other violations you've not addressed. Specifically, violations of setback requirements, vehicle parking regulations, and failure to maintain landscaping standards. Those violations have accumulated daily fines totaling $47,000. When you failed to pay, we obtained a judgment and now a writ of execution allowing us to seize assets to satisfy the debt. I grabbed the document from him. It was a court order, but from a different judge. They'd gone back to magistrate court with new violations, completely separate from the agricultural covenant issue. This is insane, I said. These are made-up violations. They're documented with photos and dates, Rothman said. You received notice of each violation. I received no notices. They were mailed to your property address. I never got them. Sharon spoke up for the first time. That's not our problem if you don't check your mail. I turned to Deputy Morrison. You can't let them just take my equipment. I'm sorry, Mr. Brennan. If the court order is valid, my hands are tied. I pulled out my phone and called Marcus. He answered on the second ring and I quickly explained the situation. Don't let them take anything, Marcus said. I'll get an emergency order. Keep them there. I turned back to the deputies. My attorney is filing an emergency motion. You need to stop this until a judge can review it. Rothman shook his head. The writ is valid. You can file whatever motions you want, but we're executing the court order now. These violations are bullshit, I said, my voice rising. Setback requirements. My equipment is on my own property, hundreds of feet from any property line. The HOA covenant requires 50 feet from the road frontage, Sharon said. Your equipment is 30 feet. That's impossible. My shop is 200 feet from the road. Your grain trailer has been parked closer. For loading and unloading. That's temporary. This went back and forth for 15 minutes while they continued securing my equipment. Deputy Morrison was clearly uncomfortable but said his job was to enforce court orders, not judge their merits. Marcus called back. I can't get a judge on the phone. Everyone's in hearings. I'm driving to the courthouse now to file in person. Yates, record everything. If they take your equipment and we prove this writ was improperly obtained, they'll be liable. I started filming on my phone. Sharon immediately objected. You can't record without our permission. This is my property, I said. I can record whatever I want. She turned to the deputies. Make him stop. Deputy Morrison sighed. Madam, he's within his rights to film on his own property. I captured everything. The trucks, the equipment being loaded, Sharon and Rothman directing the operation. I also filmed the writ of execution, zooming in on the case number and judge's signature. Then Dorothy Mills came walking over from her property. She was 75 and barely 5 feet tall, but she marched right up to Sharon. You should be ashamed of yourself, Dorothy said. This young man hasn't done anything wrong. Mrs. Mills, this doesn't concern you, Sharon said dismissively. Like hell it doesn't. I've lived here for 40 years, long before your HOA existed. This whole area was farmland. You moved here knowing that. Times change. This is a residential community now. It's still farmland, Dorothy said firmly. My husband farmed here. The Hendersons farmed here. The Brennans farmed here a century ago. You don't get to erase history because you don't like looking at tractors. Sharon's face flushed. I'm trying to maintain property values. You're trying to bully people. I was at that courthouse hearing. The judge told you that you were wrong. But you can't accept it, so now you're making up fake violations to harass this man. These violations are legitimate. Dorothy pointed at the document in my hand. Then why didn't you bring them up in the original case? Because you made them up after you lost. Rothman intervened. Mrs. Mills, These are separate matters with different legal bases. I may be old, but I'm not stupid, Dorothy shot back. This is harassment, pure and simple. The argument was still going when Marcus arrived, driving so fast he left skid marks pulling into my driveway. He jumped out with a briefcase and strode over. "Stop loading that equipment immediately," Marcus commanded. "Who are you?" one of the tow truck drivers asked. "Attorney Marcus Webb, representing Mr. Brennan. I'm filing an emergency motion to stay this writ of execution." Rothman stepped forward. "You can file whatever you want. The writ is valid and being executed now." Marcus looked at the document I handed him. His face darkened as he read. "This is before Judge Palmer," he said. "He's a magistrate judge with limited jurisdiction. He doesn't have authority to issue writs for amounts over $25,000. This writ claims $47,000. Rothman's confident expression faltered slightly. "The amount is based on accumulated daily fines, which falls under magistrate authority." "No, it doesn't. Not when the total exceeds his jurisdictional limit." Marcus turned to Deputy Morrison. "Officer, this writ is void on its face. The issuing judge lacked jurisdiction." Morrison looked confused. "I'm not a lawyer. I enforce orders I receive from courts with proper jurisdiction," Marcus pressed. "If I'm right and you enforce a void order, you and the county could be liable." Morrison picked up his radio. "Let me call my supervisor." While we waited, Marcus examined the other documents. "These violation notices, when were they supposedly mailed?" "Over the past 3 months, Rothman said, "and you claim Mr. Brennan received them." "They were mailed to his address on file." Marcus turned to me. "Did you receive any of these?" "Not a single one." "Check your mail regularly, every day." Marcus looked at Rothman. "You'll need to prove service. Merely mailing something isn't sufficient if there's a dispute about receipt. Did you use certified mail?" Rothman didn't answer immediately, which was answer enough. "You didn't," Marcus said. "So you have no proof these notices were ever received." "You filed for a default judgment claiming he was notified and failed to respond, but you can't prove notification. That's fraud on the court." Sharon stepped forward. "We followed proper procedures." "Did you?" Marcus challenged. "Or did you deliberately use regular mail knowing he wouldn't receive the notices, so you could get a default judgment?" "That's a serious accusation," Rothman said. "It's about to get more serious." Marcus pulled out his phone and made a call. "Hi, this is Marcus Webb. I need to speak with District Attorney Flores. It's urgent." "Yes, I'll hold." "What are you doing?" Sharon demanded, calling the DA. "What you've done here might constitute fraud, theft by conversion, and abuse of process. All crimes." Sharon's face went pale. "This is a civil matter. Using fraudulent court orders to seize someone's property is criminal," Marcus said coldly. "You knowingly used a defective writ from a judge without jurisdiction, based on violations the defendant never received notice of, to steal equipment worth over $100,000. That's not civil. That's criminal." Rothman put a hand on Sharon's shoulder. "Don't say anything else." Deputy Morrison's radio crackled. He stepped away to take the call, then came back looking serious. "My supervisor says if there's a jurisdictional dispute, we need to halt execution of the writ pending judicial review." "You can't do that," Sharon protested. "We have a court order." "Madam, I'm not seizing property under a questionable order. If it turns out to be defective, the county gets sued." Morrison turned to the tow truck drivers. "Unload that equipment." "We're not unloading for free," one driver said. "We already spent 2 hours loading." "Bill the HOA," Morrison said. "This is their show." Marcus was still on the phone. "Yes, I'm here. This is Marcus Webb. I'm at a property where an HOA has used what appears to be a fraudulent court order to attempt to seize a client's equipment." He explained the situation, then listened. Yes, he's here, Deputy Morrison. Okay, I'll tell him. Marcus hung up. The DA's office is sending an investigator. Everyone needs to stay here. We're leaving, Sharon said, turning toward her car. If you leave, it'll look like consciousness of guilt, Marcus said. The DA wants statements from everyone. Rothman took Sharon aside and they had a heated, whispered conversation. I couldn't hear what they said, but Sharon looked angry and scared. The tow truck drivers unloaded my equipment, grumbling the whole time. Marcus called Judge Walsh's clerk and explained the situation, requesting an emergency hearing on the magistrate court order. We all stood around my driveway in tense silence waiting for the investigator. Dorothy went home to make coffee and brought back a thermos, offering some to everyone. Only Marcus and I accepted. 40 minutes later, an unmarked sedan arrived. A woman in her 40s got out, wearing slacks and a blazer with a badge clipped to her belt. She introduced herself as Investigator Lisa Chen from the DA's office. Chen interviewed each of us separately, starting with me. I explained the whole history. The original HOA violation notices, the agricultural covenant, winning in court, the appeal, and now this attempted seizure. I showed her my phone video of the equipment being loaded. She interviewed Marcus next, then Deputy Morrison, then the tow truck drivers. Finally, she talked to Rothman and Sharon. Those conversations took the longest. When Chen finished, she gathered everyone together. Here's what I've determined, she said. The writ of execution was issued by Judge Palmer for an amount exceeding his jurisdiction. That makes the writ void. Additionally, Mr. Brennan denies receiving notice of the underlying violations, and the HOA admits they used regular mail without confirmation of receipt. That's insufficient service for a default judgment. This is a civil matter, Rothman protested. Improper service gets the judgment vacated. It doesn't make it criminal. It does when you knowingly use a defective process to seize property, Chen said. Mr. Rothman, did you know Judge Palmer lacked jurisdiction for the amount claimed? Rothman hesitated. I may have miscalculated the jurisdictional limits. That's convenient. And Mrs. Patterson, did you personally ensure the violation notices were mailed to Mr. Brennan? Sharon lifted her chin. I signed them. My secretary mailed them. To what address? His property address. Which is? Sharon pulled out her phone and read off an address. It was close to mine, but the house number was wrong. Off by 2 digits. My jaw dropped. That's not my address. That's what we have on file, Sharon said. That's Bill Henderson's nephew's place. He lives 2 miles away. Chen made a note. So the notices were sent to the wrong address. That's the address he provided, Sharon said quickly. No, it isn't, I said. My correct address is on the deed, the tax records, everything. You've sent me other correspondence before with the correct address. Chen looked at Sharon. Do you have the original application Mr. Brennan filled out when he bought the property? It's at my office. I'd like to see it. Tonight. Sharon and Rothman exchanged glances. I need to consult with my attorney, Sharon said, meaning Rothman. You're free to do that, Chen said. But I'm opening a criminal investigation into potential fraud and theft charges. If evidence starts disappearing, that's obstruction. She handed business cards to both of them. I'll be in touch tomorrow. Don't leave the state. After Chen left, Sharon and Rothman hurried to their vehicles and drove off. The tow truck drivers, finally paid by Rothman's firm to make them go away, also departed. Marcus, Dorothy, Deputy Morrison, and I stood in my driveway as the sun set. What happens now? I asked. Chen will investigate, Marcus said. If she finds evidence of criminal conduct, the DA could file charges. Meanwhile, we'll get the magistrate court judgment thrown out and file a motion for sanctions against the HOA. Will this finally end? Marcus smiled grimly. One way or another. Over the next 2 weeks, Investigator Chen conducted a thorough investigation. She subpoenaed HOA records and found something interesting. The HOA application form in Sharon's files had my correct address. Someone had changed it in their database to the wrong address before mailing the violation notices. Chen also discovered that Sharon had personally changed the address. The HOA secretary, when interviewed, said Sharon had insisted on handling the violation notices herself rather than letting the secretary mail them as usual. Additionally, Chen found emails between Sharon and Rothman discussing the need to find another angle after losing the covenant case. One email explicitly mentioned sending notices in a way that wouldn't be received so they could get a default judgment. That was enough for the DA's office. They filed criminal charges against Sharon Patterson for fraud, theft by deception, and abuse of process. Rothman wasn't charged criminally, but faced a state bar investigation for his role. The preliminary hearing was held in early December. Sharon showed up with a criminal defense attorney, a sharp woman from Atlanta who argued the case was a misunderstanding and civil matter, not criminal. The prosecutor, an assistant DA named James Park, disagreed. He presented the evidence: the deliberately wrong address, the emails discussing strategy, the defective writ, and the attempt to seize over $100,000 in equipment. This wasn't a mistake, Park argued. This was a calculated scheme to deprive Mr. Brennan of his property after Miss Patterson lost in civil court. She couldn't win legally, so she cheated. The judge found probable cause and bound Sharon over for trial. Meanwhile, Marcus had filed a motion to dismiss the magistrate court judgment and to sanction the HOA. Judge Walsh, clearly annoyed at the HOA's continued harassment, granted both motions. She dismissed the judgment, awarded me another $20,000 in legal fees, and imposed a $10,000 sanction on the HOA for filing frivolous actions. Additionally, Judge Walsh issued an order prohibiting the HOA from filing any further actions against me without first getting permission from the court and demonstrating legitimate grounds. The HOA has repeatedly abused the judicial process, Judge Walsh wrote in her order. Their actions constitute harassment and bad faith litigation. This court will not permit its resources to be used for such purposes. The appellate court decision came down in January. The Georgia Court of Appeals affirmed Judge Walsh's ruling in a unanimous decision. The opinion, written by Judge Anderson, was even stronger than the trial court decision. Agricultural covenants are an important part of Georgia's property law and heritage, the opinion stated. They protect farming rights and ensure that land can remain productive despite urban encroachment. The covenant at issue is clear, binding, and enforceable. The HOA's attempt to override this covenant is without merit. The HOA could have appealed to the Georgia Supreme Court, but they'd run out of money. Between the legal fees they'd been ordered to pay me and the costs of their own attorneys, they'd burned through their reserves. At a homeowners meeting in February, members voted to replace the entire board and dropped all legal action against me. Sharon's criminal trial was scheduled for March. She ended up taking a plea deal: 1 year probation, 200 hours of community service, restitution to me for the costs associated with the attempted seizure, and a permanent ban from serving on any HOA board. Standing in the courtroom when she accepted the plea, I felt a mix of relief and something like pity. Sharon had let her desire for control destroy her life. She'd lost her position, her reputation, and gained a criminal record, all because she couldn't stand the sight of farm equipment. After the plea hearing, Marcus and I walked out of the courthouse into bright spring sunshine. "It's finally over," I said. "For now," Marcus replied. "But Yates, I want you to do something for me." "What's that?" "Record a new deed covenant. Make the agricultural protections even more explicit. Name specific equipment, specific activities, everything. Make it ironclad so nobody can ever try this again." "Can we do that?" "Absolutely. You own the property. You can add protective covenants. We'll reference the original 1887 covenant and expand on it with modern language. Future owners will have the same protection." We did exactly that. The new covenant, recorded in April, explicitly listed agricultural activities including equipment storage, crop harvesting, equipment repair, and commercial farming operations. It stated these rights could not be restricted by any HOA, zoning regulation, or other limitation. It invoked the original 1887 covenant and Georgia's agricultural protection statutes. With that done, I finally felt secure. Life returned to normal. I rebuilt my client relationships and had a strong harvest season that year. My reputation actually benefited from the legal battle. Other farmers saw me as someone who'd stood up to HOA overreach and won. Dorothy Mills became a good friend. She'd bake pies and bring them over, and we'd sit on my porch talking about the old days when the whole county was farmland. Bill Henderson and I became friends too. He taught me about the area's farming history and shared stories about his Uncle Frank, the man who'd sold me the property. "Uncle Frank would have loved seeing you beat that HOA," Bill told me one evening over beers. He fought them for years. Toward the end, when he knew he couldn't farm anymore, he made sure that covenant was front and center in the deed. He told me, "This land's been farmed since before the Civil War. I'll be damned if some busybodies in a subdivision stop that." I wish I'd met him. He was a stubborn old cuss. You remind me of him, actually. Same backbone. The new HOA board reached out to me that summer with an apology and a proposal. They wanted to establish agricultural protection zones in the subdivision, formally recognizing that several properties, including mine, were working farms. They proposed amending the HOA covenants to explicitly exempt agricultural operations. I worked with them on the language, making sure it was strong and clear. In September, the homeowners voted 92% in favor of the amendments. Meadowbrook Estates officially became a mixed-use community, residential and agricultural. Some people moved out, preferring purely suburban neighborhoods. But others moved in, attracted by the rural character. Property values didn't crash like Sharon had predicted. In fact, they rose slightly as the community developed a reputation as a unique blend of country and suburb. I expanded my operation, adding another harvester and 2 more employees. I bought an adjacent 10-acre parcel that came up for sale and added more shop space. 2 years after the legal battle ended, I was working on a tractor when a car pulled into my driveway. For a moment I tensed, having a flashback to Sharon's BMW. But this was a Honda sedan, and the woman who got out was young, maybe 30, with a friendly smile. "Are you Yates Brennan?" she asked. "That's me. I'm Amanda Torres. I'm a reporter with the Atlanta Journal-Constitution. I'm doing a story about agricultural rights and HOA conflicts. Your case came up in my research. Would you be willing to talk?" I hesitated, then agreed. We sat on my porch and I told her the whole story. Amanda took notes and asked thoughtful questions. "Why was this so important to you?" she asked. "You could have moved, found property elsewhere without an HOA. I thought about that. Because I was right. The law was on my side, history was on my side, and I had every right to be here. If I'd backed down, it would have sent a message that HOAs can bully people out of their legal rights. I didn't want that, and honestly, I loved this property. My ancestors farmed it. That meant something to me. Your ancestors. Thomas Brennan, the man who established the original covenant in 1887. Turns out he was my great-great-great-grandfather. I didn't know that when I bought the place, but I traced the family tree after the case. He was a farmer who homesteaded this land after the Civil War. He put that covenant in place because he'd seen too many farmers lose their land to development and wanted to protect it forever. Over 130 years later, that covenant saved my farm. That's pretty amazing when you think about it. Amanda's article ran a month later on the front page of the Sunday edition. It told my story, but also covered the broader issue of agricultural land preservation and the tension between suburban development and farming rights. The article mentioned Dorothy, Bill, and even quoted Marcus about the importance of historical covenants. The story got picked up nationally. I did a few radio interviews and even appeared on a Georgia public broadcasting segment about rural land preservation. Through it all, I kept farming. That was the point, after all. The legal battle had never been about fame or making a point. It was about my right to farm my land, to continue a tradition that stretched back generations, and to make an honest living doing work I loved. Standing in my field one evening as the sun set over my equipment, I thought about Thomas Brennan, my ancestor who'd had the foresight to protect this land forever. I thought about Frank Henderson, who'd honored that protection by highlighting the covenant when he sold to me. I thought about Marcus, Dorothy, Bill, and all the people who'd stood with me. Most of all, I thought about Sharon Patterson and the HOA board who tried to take it all away. They'd failed, not because I was stronger or smarter, but because the law, history, and basic property rights were on my side. Some things are more important than neighborhood aesthetics or property value fears. Some rights, once established, endure forever. As I walked back to my house, I passed my equipment lined up near the shop, the combine, the tractors, the grain hauler. They looked beautiful to me, symbols of honest work and agricultural heritage. Let them sit there forever, I thought. They had every right to be here. And thanks to an 1887 covenant and a lot of legal fighting, they always would.